A Kentucky elementary school teacher and middle school soccer coach is accused of sexually abusing a 10-year-old girl inside a school bathroom. The girl, who's now a teenager, came forward to reveal what she says allegedly happened to her. But now, on top of being on leave and banned from school property, he faces a very serious charge. But we are going to break down what exactly the evidence may show. Welcome to Sidebar, presented by Law&Crime. I'm Jesse Weber. 40-year-old Charles Charlie Hamilton is under arrest in Madison County, Kentucky. And I will tell you, if these allegations are true, he could be looking at prison time for a significant amount of time. This alleged victim, just 10 years old back during the 2018-2019 school year, and that time period is important, recently came forward to claim that Hamilton touched her inappropriately inside a school bathroom during a power outage. I want to break down this case. I want to welcome back on Prosecutor, former Ohio Deputy Attorney General Mark Weaver. Mark, thank you so much for coming on. Really appreciate it. Talk to me about the challenges of bringing a case years after the alleged crime when somebody only comes forward so many years later. I mean, doesn't negate that this happened, but it can complicate a case. It can make it a little bit challenging, right?
Sure. Two things viewers should know. One, statutes of limitations for child sex cases are usually very long, in many cases 15, 20, 25 years. Secondly, those statutes typically don't start running until the child turns 18. And so there's plenty of time legally to bring the case. But you raise an interesting point. Witnesses may have left and moved on somewhere else. People who were at that school at that time who knew about the power outage, maybe they moved to another state, not available. Digital records of what might have happened, if there's any email traffic, texting, social media at the time, that's largely gone. This may very well come down to the classic he said, she said, and defense lawyers can take advantage of that issue.
Now, my understanding is in Kentucky, there's no statute of limitations, even on felonies, and I think he's charged with first-degree sexual abuse, which is a felony, so that's a good point. I will say this, Kentucky news outlet Lex 18, they got their hands on this warrant that was filed against Hamilton. It provides a little bit more information. I want to get into it. So according to their reporting, this alleged victim, who's now 17 years old, she reportedly told her therapist that a teacher touched her inappropriately when she was just 10 during the 2018-2019 school year. That therapist reported the allegations to the Department of Community-Based Services. It's part of the Cabinet for Families and Children. And the teen met with DCBS, explained what happened. Mark, explain to me how that works. Is a therapist a mandatory reporter? Isn't there some sort of confidentiality what is told to the therapist? How does that work exactly?
Although I don't practice in Kentucky, in most states, there is a protection for things you tell your therapist. But when it comes to certain criminal offenses, particularly child sex offenses, states will allow that to be revealed. And people who work with children do tend to be mandatory reporters. Having said that, without respect to knowing what this case might be, that could be the motion, a suppression motion could be filed in this case where the defense counsel would seek to exclude that under some argument along the lines of that it should not have been revealed.
Right. Okay, so according to the arrest warrant, Boonesboro Elementary School in Richmond was dealing with a power outage one day. And this is when this 10-year-old girl had apparently asked Hamilton to go with her to the bathroom. She said she was scared of the dark, didn't want to go alone. However, according to the Lexington Herald-Leader, the student didn't want Hamilton to actually come into the bathroom with her, but he allegedly did. Now, the girl reportedly told authorities that when she'd finished up in the bathroom stall, and that is when she says that he allegedly touched her genitals. Hamilton's other hand was allegedly wrapped around the child's waist and back. Lex 18 reports the warrant reads, when she left the stall, Hamilton then reached down and touched her over her clothes and asked her if this was okay. Now, Mark, obviously, a disturbing allegation. The complication, let's go back to this one more time. How do investigators actually corroborate that? How do they prove an allegation like that? You know, even aside from, what is this, 6 or 7 years ago, but the circumstances of this interaction, you wonder if a defense attorney is going to say, is this being misinterpreted? Is this being exaggerated? Did this actually happen the way that she said? It may very well have, and if that's the case, then you could understand why this charge is being pursued. But at the same time, you do wonder, how can they corroborate this?
Corroboration will be the heart of this case. The first thing investigators will do is to check employment records to see that this teacher was in fact working on that day, and attendance records that in fact this child was in school on that day, and then power records, going to the power plant company to confirm that there was a power outage at the same time on that same day. Absent one of those three, the defense can get a verdict of acquittal without even getting into the credibility of this child, now a teenager. If those three things are all there, now it's going to come back to the he said, she said, and now this is the very uncomfortable time when our system permits the criminal defense lawyer to cross-examine this victim in a very aggressive fashion, usually not in a way to bully her because the jury wouldn't like that, but in a way that might make it seem as though she's confused. I have prosecuted child rape cases. I have seen criminal defense lawyers do exactly that. Any little moment of daylight where they can suggest that maybe her credibility is not worth relying on, they will take advantage of.
And particularly, and this is not judging the situation, it is not putting blame on anything, but if she admitted that she gave him a hug, that could be a complicating factor. Now, one thing can be true and one thing can also be true, right? The allegation could be, yes, I gave him a hug, but then he took it to the other level, and that could 100% be true. But when you are talking about beyond a reasonable doubt, obviously there can be complications here. But let me tell you what happened here. So as this investigation got underway, Madison County Schools, they placed Hamilton on leave. And according to posts on the elementary school's Facebook page, he had taught third grade. His Facebook page, as well as a page for the elementary school, show him surrounded by students in classrooms, at sports events. Fox 56 reports that Hamilton voluntarily surrendered to authorities on October 13th. He was charged with first-degree sexual abuse of a victim under the age of 12. Mark, if this is true, right, what are the benefits of turning yourself over, not fighting this, complying? Would it suggest that he is ready to take this to trial, that he believes he didn't do anything wrong, that this is a misunderstanding? Or does this just, even if he were guilty of this, even if the evidence were strong, this is advisable to do in a situation like this?
He may want to take that form of a plea, but the prosecutor also has to look for digital evidence of other instances of this man being attracted to children. We don't currently have evidence that he was looking or collecting child porn or that he acted out against any other student, or I think he was a girls' soccer coach, any other player. But that's the sort of thing investigators and prosecutors are looking for now. The more they can build their case out and potentially supersede this indictment with additional charges, the better leverage the prosecution has to get this defendant to plead guilty.
By the way, you know why we're able to really do a deep dive on a story like this? It's not only because of the amazing support that we get from everyone out there, thank you so much, but it's also because of the support that we get from our incredible sponsor, Morgan & Morgan, America's largest injury law firm, a firm with over 1,000 attorneys. You know why they're so big? Because they win all the time. They have recovered over $25 billion for more than 500,000 clients. In the past few months, a client in Florida received $12 million after the insurance company offered just $350,000. Out in Pennsylvania, a client was awarded $26 million. That is 40 times the insurer's $650,000 offer. You have another client in Pennsylvania that received $29 million after being offered only $500,000. And even if you think your case isn't worth millions of dollars, why not just start a claim and fight for what you deserve? Morgan & Morgan makes it so simple. You can start a claim from your phone in just 8 clicks. So if you're injured, you can easily start a claim at forthepeople.com/LC Sidebar by clicking the link below or scanning the QR code on screen. Now, Madison County Schools says that Hamilton was placed on leave on September 8th, so that is the same day that the district found out about the investigation from DCBS. Lex 18 reports that the warrant states Hamilton is banned from all school property in Madison County, can't have any contact with his alleged victim. A statement from Madison County Schools to Lex 18 said the district was notified of the beginning of the investigation by DCBS. No information about the investigation was given, including the nature of the investigation, until yesterday when we were notified he was being charged. We received no additional information. The communication families received from the school indicated Mr. Hamilton would be out of the building and gave information about reassigning students for the time being. They added Mr. Hamilton has remained on leave since September 8th and has not returned to his teaching or coaching duties. The district will continue to cooperate fully with the investigation. And Hamilton wasn't just a teacher, he was also, as you just heard, a soccer coach at a nearby middle school. A Facebook post from B. Michael Caudle Middle School in April of 2023 announced Hamilton as the new girls soccer coach. And back in 2022, Burnsboro Elementary posted an educator spotlight of Hamilton on its Facebook page. It said, quote, "This is my 13th year in education, and I've been at Boonsboro since the doors opened. I've taught 5th and 3rd grade here at BES. My pull toward teaching information came while I was in college working with an after-school program through the YMCA. I love the idea of being able to help a student become the best version of themselves both inside and outside the classroom. I'm very thankful for my team at BES who make showing up every day seem easy. Outside of Boonesboro, I'm very passionate about soccer and all sports. I have coached soccer the past several years and absolutely love the game. This love has recently turned into my very own podcast with the hopes of building a brand around the game. Now, Hamilton was given a $50,000 bond. It's unclear if he's been released from pretrial detention. He has an arraignment that's scheduled for Monday, October 20th. Mark, what is the role of the school and the school district here?
I've come alongside school districts when teachers have been accused of crimes like this and advised them. Number one is they need to be transparent with parents about what's happening. Parents are responsible for their children's safety when they're with them, and then they give their kids over to the school for 7 or 8 hours every day, and they expect the school to then be responsible for their child's safety. So number one, they have to make sure this teacher is no longer around children. Number two, be honest and transparent with parents about what the school does to protect the children and how the school is working to make sure investigators can get to the truth in this case.
Do you think there's more here than we see? I mean, do you think they have more than just the account of this alleged victim? Do you think that they have perhaps corroborating statements before they move forward with a charge against a teacher like this?
Most of the child sex cases I've worked on or read about over the years suggest that once someone shows us that they are attracted to children, it's not a one-off incident. It just doesn't happen one time. Something else is happening, whether it's child porn, whether it's acting out against other children. Typically, there's more here. I hope there's not, for the sake of, I don't want there to be more victims. I'd be surprised if this was the only time this person has acted out.
How do you think this is going to play out? How do these cases typically play out? I know each one is different. The allegations are different. The charges are different. The circumstances are different. But how typically does it? You always go to trial? Do you see a plea deal? Do you see charges being dismissed? I mean, how do you see these cases usually playing out?
I tell defense lawyers that I prosecute because I like to bring jury trials and I like to be in court. Having said that, I will not take the desire to try a case and balance that against the desire to protect a victim. I'd always rather protect the victim. So as a prosecutor, I want to make sure, and this is with a 17-year-old girl, she's still a minor. I'd like to see if I can get a conviction without forcing a child to take a stand and explain what might be the most embarrassing moment of her life in front of a room full of strangers, and then subject her to the withering cross-examination of a highly skilled and trained defense lawyer. So when possible, I am willing to dismiss some charges if the defendant will take responsibility for some other portion of the charges and if the victim is willing to bless that arrangement. The charges belong to the prosecutor, not to the victim. But when possible, we get a better result with a plea because we're not rolling the dice on whether there'll be an acquittal by the jury, and we don't have to put the victim through years of appeals and potentially reversals and new trials.
A couple of questions here as I'm thinking about this to corroborate her account. Between the time this allegedly happened and when she told her therapist, I wonder if she exhibited any kind of behavior. Well, first of all, I imagine she would have to take the stand in a trial to explain what happened. I also have to imagine people would testify to say her personality changed, something changed. They observe, or she may have told them something over the years. You wonder, is the therapist the first person who ever knew or saw something? And I wonder if that's part of the investigation too. So I guess the two questions I have for you are, that's probably going to be a part for the prosecution to see, has she told anybody this, or did anybody observe any change in her behavior, her personality, anything, her actions? And can the therapist testify too?
Well, now we're getting into evidentiary rules, but let's do it. The girl, she takes a stand, she can testify that she told her mom, her dad, her friend, this person, that person. She can do that. Those people cannot testify that they were told because that would be hearsay. That's not allowed. That's a out-of-court statement offered to prove its own truth. The defense would object, and the judge would likely bar that testimony. Now, there are some exceptions to the hearsay rule. I don't see one for this one here. But the girl herself could testify that she, in fact, told other people. If there were outside proof of that, it's still hearsay, but there's other exceptions that could come in. Having said that, I think people should remember when a victim comes forward with a story like this, the defense counsel is going to try to make the jury to think the victim is a liar. I had a child sex prosecution once where the defense lawyer put on witnesses from the neighborhood who say, I know this girl, she's a liar. She told me a lie once. And they tried to use that to suggest that she was a liar. Now, I undid each of them in cross-examination by simply asking them if they had ever told a lie before. And every one of them under oath had to say they did. So it's able to blunt the effectiveness. But we see this sometimes where the argument of the defense counsel is she can't be believed because she lied once about a babysitting job, or she lied once about some money from Girl Scout cookies, something like that.
Well, just to back up here, first of all, they could testify, maybe not about what she told them, but they could testify, did you observe any change in her demeanor? Did you see anything, that would maybe support it? But also the therapist, right? Can the therapist testify?
Typically not. There is an exception for statements made for the purposes of medical diagnosis. So there is that hearsay exception. So perhaps it comes under that. But the point you make is a good one, Jesse, is people can testify. Now that you mention it, I remember that power outage, and shortly thereafter, she dropped out of this team. She stopped going to this club. She didn't seem as outgoing as she once was. That's all valid testimony. Those are not hearsay statements. Seeming to act differently after a traumatic event is something that could come in as evidence if, in fact, those things happened.
Mark Weaver, this is a disturbing new set of allegations here. Curious to see how it plays out. We're in the early stages of it. We talked about some of the different factors to consider, and we don't have a ton of information, but again, we'll keep a careful eye on it. Mark Weaver, thanks so much for taking the time. Appreciate it.
Thank you.
And that's all we have for you right now here on Sidebar. Everybody, thank you so much for joining us. And as always, please subscribe on YouTube, Apple Podcasts, Spotify, wherever you should get your podcasts. You can follow me on Instagram or X. I'm Jesse Weber. I'll see you next time.